Hello, my name is Michael Tessara and I've prepared this video case note on the recent case of Commonwealth Director of Public Prosecutions and Vina Money Transfer. This is an important case because it's the first case in which the Federal Court has imposed a sentence of imprisonment in relation to a number of individuals for breaches of the cartel conduct provisions of the Competition and Consumer Act. Bit of background about myself: I'm a competition and consumer lawyer, been running my own practice, Tessara Legal Consulting, for 14 years. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including in enforcement and mergers and asset sales. Outline of the presentation: I'll start with the background, discuss the guilty pleas, then look at the sentencing legislation, then discuss the decision of Justice Abram. I'll go through that in a bit of detail, then finish with some commentary. The background to the case was Vina Money Transfer, Hong Vina Fast Money Transfer, and High Heart Money Transfer were alleged to have engaged in a cartel in relation to the remittance of funds from Australia to Vietnam. And these companies were fairly significant in the market. They contributed quite a large share of the market of money transmitted back to Vietnam from Australia. And I think the market was valued about $2.5 billion. So it's quite a significant market. Now, the conduct they were alleged to have engaged in was entering into an agreement that contained two cartel provisions. The first of the cartel provisions was that they would offer their customers a common exchange rate, so they'd agree on the level of exchange rate to offer customers. And secondly, that they would cease to apply fee discounts on the money remittances they were offering to consumers. So on the 3rd of February 2022, a number of the parties pleaded guilty to the charges. Vina Money pleaded guilty to two offences of giving effect to these two cartel provisions, namely the agreement to charge a common exchange rate and also not to offer fee discounts to their customers. And the thing to note there is there was no charge in the indictment of making a cartel agreement. Rather, they were charged with giving effect to the agreement. Also, on the 3rd of February, the director of Vina Money pleaded guilty to the two offences in relation to the exchange rate and the fee discount. And Tony Lee, who was an employee of Vina Money, pleaded guilty to one of the charges, which is effectively the exchange rate charge. Also, the director of Hong Vina pleaded guilty on the 3rd of February to one of the offences, which is effectively the exchange rate agreement. And then on the 17th of May, the final defendant pleaded guilty from Hong Vina to both offences. Firstly, being only concerned in giving effect to the exchange rate agreement and also giving effect to the fee discount agreement. There was also a cooperating witness, Diane Nguyen from High Heart Money Transfer, had been granted immunity for being a DPP prosecution witness, and she was granted full immunity from any charges, and her company as well. Now, the way this case arose is somewhat unusual. Usually what would occur is that one of the parties to the agreement would decide to go to the ACCC to blow the whistle on the cartel and seek immunity. But in this particular case, the ACCC found out about it as a consequence of a criminal investigation by the Australian Criminal Intelligence Commission, or probably better known as the Australian Crime Commission, when they intercepted a communication between a number of the defendants, which indicated to the Commission that the parties may be engaging in illegal cartel activity. So once the ACIC had determined there may be cartel activity occurring, it decided to refer the matter to both the Australian Federal Police and the ACCC. So this is a very unusual and somewhat unlucky way for a cartel to come to the attention of the ACCC. Another very significant aspect of this case is the role of Sacom Bank, which is one of the two largest Vietnamese private banks, and it was the company to which the three Australian remittance companies were sending funds. And Second Bank noticed that the three Australian companies were competing very fiercely against each other and offering very high exchange rates to their customers, and actually encouraged them to rethink that strategy and potentially to enter into an agreement to cease competing. And just to give you a flavour for the types of communications that were occurring, in the judgment, there's a copy of this email from Second Bank to the parties to the cartel agreement, where the Second Bank saying that the situation you're in at the moment will lead to losses. You can't let your clients who are sending money to Vietnam benefit unjustifiably, illegitimately, by offering them such high exchange rates. You really need to get out of this lose-lose situation and change the exchange rates which you're offering to your customers. Then in the last paragraph there, I do hope that you all reach a mutual agreement to start doing this right. So effectively, Second Bank has strongly encouraged the three Australian companies to enter into some agreement to increase or to decrease the exchange rate that they're offering to their customers. This is a very unusual aspect of this case. Now, when you're sentencing a company or an individual under the cartel provisions, you have to look at the Crimes Act section 16A, and the overriding principle of 16A is set out in subsection 1 there, which is to impose a sentence that is of a severity appropriate in all the circumstances of the offence. So you've got to consider all the circumstances of the offence and work out a penalty that's appropriately severe for that conduct. Then there's a range of factors listed which the court must take into consideration when setting a sentence. First is the nature and circumstances of the offence. So that could be things like how long the offence has been engaged in, whether the companies have generated a lot of profits from the illegal agreements, whether it was engaged in a surreptitious or premeditated manner, those type of factors. Then you also look at whether there's any other offences that can be taken into consideration, whether the offence forms part of a course of conduct, series of criminal acts. The personal circumstances of the victim are very relevant. The injury, loss or damage resulting from the offence, and in this particular case, the court was not able to determine how much detriment had been caused to consumers by the conduct. If the individual who is a victim of the offence has suffered harm, any victim impact statements. So it's very common for victim impact statements to be filed in these type of proceedings to determine what negative impacts the offending has had on that person. Also, whether the defendant has shown contrition, and that can be demonstrated by making reparations for any injuries or loss. This is an interesting one, the extent to which the person has complied with pre-trial disclosure or ongoing disclosure obligations. This is a funny one where they're sort of saying that if you haven't complied with these pre-trial or various obligations, that could actually negatively impact you at the sentencing stage. Next one is if the person has pleaded guilty and also how early they pleaded guilty. So obviously pleading guilty is beneficial, but pleading guilty at a very early stage has a big utilitarian value because it's prevented the community from having to, I guess, pay for a long trial. Victims have been spared the trauma of having to give evidence. Witnesses have been spared the time of having to go to court. So the utilitarian value of an early guilty plea is actually worth quite a lot in sentencing. The degree to which the person has cooperated with in this case, the ACCC, the deterrent effect which the sentence will have on the person, so that's specific deterrence. Also, the deterrent effect that the sentence will have on other people who may be minded to break the law, so that's general deterrence. The need to ensure that the person is adequately punished for the offence, so that's just desserts, making sure that the person is punished appropriately for what they've done. Looking at the character, antecedents, age, mental condition of the defendant, and that's quite relevant in this particular case. The person standing in the community as a consequence of being charged, which is again a very relevant factor in this case, and the prospects of rehabilitation. So they're the factors that have to be taken into consideration by the court. Now, a approach to sentencing has been set out by the judge in her judgment, and she goes back to this idea of the instinctive synthesis as set out by McHugh, Markarian and the Queen, where says that the method of sentencing involves the judge identifying all the factors that are relevant to sentence, which we've just gone through, discuss their significance, and then making a value judgment as what the appropriate sentence is given. So this is moving away from maybe a mathematical approach to sentencing and more of an instinctive synthesis of all the factors. A very significant factor, however, is the guilty plea, but its timing, and the timing has a significant utilitarian value to the community, to the victims, to the witness. So that's a very big consideration. And also, an early guilty plea is a good indicator that the defendant has subjectively demonstrated true remorse and contrition. So these factors probably gain a larger weighting in the instinctive synthesis process. Obviously, Markarian talks about setting or identifying what the maximum penalties are for the conduct, and that's what the judge did in this case. And in terms of the corporate defendant, Vina Money, she was of the view that they couldn't work out what the benefits were arising from the legal conduct, so couldn't work 3 times the benefit from that conduct. Also accepted that Vina Money's annual turnover during the relevant period was less than 100 million, so that 10% of turnover figure didn't apply. So really the maximum penalty for each of the 2 offences was $10 million. And then secondly, the maximum penalties for individuals, that was much easier to work out. Clearly it's a term of imprisonment not exceeding 10 years or a fine of $220,000. So the director makes a number of submissions to the court about various issues, and in this particular case, the key submission the director made to the court was that looking at each offender, the objective seriousness of their conduct, the conduct should be characterised in the low to moderate range of offending. So second that submission is made to the court, you're looking at penalties at the lower end of $10 million, so you're looking $1 or $2 million penalties, and you're also looking at terms of imprisonment at the lower end, 1 or 2 years. Other submissions made by the director to the court included the fact that this offence had been committed for financial gain, which is, I think, not seriously in dispute. There was also a degree of sophistication, planning, and cooperation involved in the offending, so it wasn't just an ad hoc or on the spur of the moment type conduct. It involved a degree of planning. There was a lot of communications between the parties to make sure they were complying with their obligations under the agreement. Also, the pleas of guilty and the early timing were very significant factors. High utilitarian value, so that's a very big factor in favour of a lower sentence. They also acknowledged that there had been significant delays in the proceeding, not just due to the complexity of the case, but due to COVID. And this is something that benefits the defendants because they've had the charges hanging over their head for a much longer period of time. So they got some credit for that. And the director also acknowledged that there were good prospects of rehabilitation for all the defendants. So the court, in weighing up everything, focused a lot on the fact that the offences were serious. There was no doubting the cartel conduct serious. There's serious and significant penalties imposed for that. She was a little bit concerned about some of the submissions which the defendants made that seemed to argue that the conduct was less serious. So that sort of is a dangerous strategy to undertake because it does sort of undermine the whole idea of contrition and insight into the illegality of conduct. So she wasn't unimpressed by some of those submissions, particularly the suggestion that the overseas Vietnamese bank had some complicity here and some responsibility for encouraging the Australian companies to enter into this illegal agreement. A number of the defendants had no prior convictions, although a couple did. All the defendants had shown remorse and contrition. Good character seemed to be a relevant factor for a couple of the defendants, but not necessarily all of them. The guilty plea at an early stage was significant for all defendants, and they obtained discounts off the sentence of between 20 and 25%, significant discounts. As considered by the director, each of the defendants had good prospects of rehabilitation. It's a very big factor, particularly in relation to the recognizance release order. The judge looked carefully at the personal circumstances and concerns for the welfare of the family of the defendants, and that varied. Some of the people, there was bigger considerations having to looking after other family members who were unwell, but that was a big factor for some of the sentencing decisions. And I think a fairly big factor was the loss of the business. So Vina Money effectively went broke and lost a contract or a license with a larger money remittance company as a consequence of the charges. And the standing of the community, in the community of a number of defendants, have been seriously impacted by these charges. So weighing up all those factors, the judge came to the view that a sentence of imprisonment should be imposed. She dismissed the suggestion that a sentence of imprisonment should not be imposed. She's clearly thought that that submission was not accurate. The facts of the case required a sentence of imprisonment. So in relation to Vina Money, there was two elements. There was obviously what should be the fine for the exchange rate agreement and what should be the fine for the fee discount agreement. And she decided that due to the length of the first one, was approximately 5 years, a penalty of $900,000 should be imposed. And in relation to the fee discount agreement, which is much shorter, a penalty of $187,000. So she discounted that a slight bit under the idea of totality. So she imposed a penalty of $1 million against the company. The company gone into liquidation, so none of these penalties can actually be paid. In relation to the director of Vina Money, found that a penalty of 2 years and 1 month for knowingly concerned in the exchange rate agreement, and then a sentence of 8 months for the fee discount agreement. And the discount of 25% was applied to the sentences, to the periods of imprisonment in both charges. And due to some overlap issues, it resulted in a total effective sentence of 2 years and 6 months. In relation to Tony Lee, was only implicated in one of the two offences in relation to the exchange rate agreement. He was in a sentence of imprisonment of 9 months. He did make a submission to try and have the charges dismissed without a conviction being recorded, and that failed. The court did not believe that it was appropriate, that the submission that was made in relation to 19B was unrealistic, as a period of imprisonment had to be imposed. Then in relation to Kai Tran, it was relevant that he had some previous offences in relation to unregistered operations of remittance service and also some allegations dealing with the proceeds of crime. And he'd previously been sentenced to 2 years imprisonment, which was subject to a recognizance release order. So this had some bearing on the penalty that was imposed against him. And accordingly, the sentence was 1 year and 7 months for giving effect to the exchange rate agreement. The final defendant, there were quite a number of considerations that had to be weighed up in relation to her charge. Firstly, the court noted that when the ACCC investigating officials had come to her premises and executed a search warrant, or to a home actually, she was very open and cooperative with them. So that was a factor that counted in her favour. However, she had prior criminal history for failing to answer a question in an ACCC investigation, as well as some allegations of unlicensed money remittance operations. And for those earlier offences, she'd been sentenced to a term of imprisonment of 26 months and was immediately released on a recognizance release. So all these factors, some obviously counted in her favour and some counted against her. But what occurred, I think, here was that the court concluded that she'd been very forthright. She hadn't sought to minimise the seriousness of the conduct. She had been open about issues when approached by the ACCC. So that I think assisted her in the charges, even though she had quite these previous criminal offences. And so the court imposed a penalty of 1 year, 10 months for the first offence, 9 months for the second offence, and once some overlap was taken into consideration, a term imprisonment of 2 years and 4 months. And she was given a discount of 20%. And the next issue is whether they should be subject to a recognizance release. And the key factor here is the director saying to the court that a decision by the court to allow the defendants out on a recognizance release would not be an appellable error. So that's effectively saying to the court, well, if you decide not to imprison these individuals but to release them on a good behaviour bond, the DPP won't appeal that decision as being wrong in law. So that's a pretty good message to the court that they can go ahead and release the defendants on this good behaviour bond. It's a funny thing that I find in criminal cases where the DPP is telling the court whether a decision that it might be minded to make will constitute an appellable error or not. It doesn't occur in the civil area. Now, when the court looks at the issue of recognizance release, there is probably a bias towards releasing individuals on a recognizance release order, and that's all under Section 19AC of the Crimes Act. And the purpose of this recognizance release order is to see whether the individual would be best allowed to be released on their own recognizance due to the strong prospects of rehabilitation. And so in this case, the director said to the court that the individuals had good prospects of rehabilitation, so that really favoured the recognizance release order. So what the court decided was, when you looked at the early guilty pleas, the subjective factors that supported that there'd been true remorse and contrition, that they had good prospects of rehabilitation, that once all those factors were taken into consideration, it was appropriate to fix a recognizance release order in relation to all of the defendants. And there you can see what the court decided. Effectively, for most of the defendants, a 3-year, $1,000 recognizance release, and for Mr. Lee, 1 year, 6 months, and $500. There's just some commentary about it. I think the outcome is a fair outcome. I don't think these people should have been imprisoned. I think that obviously the DPP seemed to be in the same view of the court. It supported the view that they were at the lower end of the spectrum. The offending also supported the view of the recognizance release. So I think the court and the DPP were in agreement as to the penalty. I think it's the right penalty. The question that arises is whether the ACCC should have pursued a criminal case in this matter, and I think it probably shouldn't have actually. These are small businesses who were not sophisticated. There was a strong factor that the Bank in Vietnam was encouraging these individuals to enter into the cartel arrangement. So I think on balance, it wouldn't be the type of case that I think the ACCC should pursue criminally. I think this would have been a case that a civil case would have been appropriate. I don't think necessarily the facts of this case are going to do damage to future ACCC cases. I think if the ACCC takes cases against small businesses who engage in cartel conduct in order to protect their businesses, I think courts and juries are likely to either impose a very low level of imprisonment, or I think actually in terms of juries, they're highly likely to acquit small businesses in this conduct. I think the ACCC needs to rethink the types of cases taking. I think taking small businesses to court on criminal proceedings such as these is a mistake, because while the court did impose periods of imprisonment, most juries would have acquitted these individuals, I think. So I guess going forward, we'll see what the next cases are. There'll be another sentencing hearing coming up in the Alkaloids case, which involves an individual and a corporation. And as far as I'm aware, that's probably it. That's the final criminal cartel matter that's before the courts. Be interesting to see the next one that comes along. But I guess what would be more beneficial, I think, for all concerned is a case against a larger, more sophisticated company. And I guess to get some meaningful case law out of this area, I guess we hope it's contested and not a guilty plea. So that's all I've had. If you've got any questions about this, feel free to give me a call or drop me an email.